aspects of the Customs Act of Indian Customs Provision, which is very much aligned to the government vision of Make in India. So before deliberating further on this legal provision, what we call Section 65 of the Customs Act, let me mention here that this provision of manufacturing under bond, manufacturing and other operations under bond is not a new concept. And if I may say so, it is historically there since ages. I would add here, since ages, in different countries, in different forms in their customs regulations. So when we are talking about India, even before independence, we had certain specific sectors in which this provision was applied, was allowed. For example, if I may quote such as wine and spirit, tobacco and cigarettes, motor spirit, electric gramophone. I mean, you can consider, you can imagine the industrial development of that time and then consider this particular provision was still there at that time. Even in the independent India, we allowed a few more sectors such as ship repair or motor vehicles, handicrafts. But what was happening at that time, there were a number of rules and regulations which were sector specific. So what government thought at that time, let us make a general provision. And that is how, after the new Customs Act was put in place in 1962, 4 years later in 1966, a general regulation of manufacturing and other operations under customs bonded warehouse was introduced. So since then, we are calling it MOOWR regulation, and it is well in place for so many years. In fact, if I may say so, when the EOU scheme was introduced in 80s and 90s, at that time also, it was envisaged initially as if it was manufacturing under bond, and all provisions of Section 65 were applicable. Later on, sometime in 2017, it was delinked. So, what happened in 2016? In 2016, government did a lot of reforms so far as warehousing provisions are concerned. And we revamped the entire warehousing chapter of Customs Act. It was basically aimed at liberalizing and simplifying the provisions. For instance, we completely done away with the physical control, except for a few special warehouses. In all public and private bonded warehouses, nowadays there's no physical control. So at the same time, we also introduced record-based control, what we can call audit-based control. We also introduced simplified accounting, digital accounting, and so many provisions were introduced. So then there was a thinking that when all this liberalization was happening, this is the right time to think through it and use it as an opportunity to introduce, or rather repackage, this entire gamut of manufacturing under bond in a more simplified and user-friendly manner. So that was the background of the new scheme. In 2019, sometime I think in the month of May, the first regulation was issued, the new regulation was issued. And thereafter, we also held a number of users interactions, stakeholder seminars. We gathered a number of very important suggestions, feedback. We accounted for all those suggestions and feedback wherever we thought that it is possible. We incorporated everything, and then another regulation, I would call revised regulation, was issued. We call it MOOWR number 2 regulation of 2019. That was 1st of October 2019. And at the same time, a very comprehensive circular 34 by 2019 was also issued to explain different provisions of the new regulation. Since then, if I may say so, this department, CBIC, has been interacting with all the stakeholders. We are in our exercise to gather more and more feedback, more and more suggestion, and we are looking forward to making more improvements so as to make this scheme more attractive. So at this time, I take this opportunity to introduce my colleague who is also joining me, She is Ms. Tamsinaro Jamir, Additional Commissioner on International Customs Division. I would say that she is the author of the new regulation as well as the new circular. Recently, she has also issued a number of frequently asked questions. And to make the scheme more user-friendly, she also collaborated with Invest India. And there is a specific website, I would say a web portal available on Invest India website. And it is also linked to CBIC website, where all relevant information, forms and documents, frequently asked questions, everything is available. So I request everyone who is interested in going forward with this scheme to please have a look. And you will also find very user-friendly electronic submission of application. That facility is also available. Now, coming to the basic provision of the scheme, as we all know, this is manufacturing under customs warehousing. Meaning thereby, we are not going to ask for duty payment when the goods are being imported for use under a warehouse for manufacturing or other processes. So this is the first point of duty deferment when the goods are getting imported into India for being taken to a warehouse. Thereafter, it is allowed to be used in manufacturing, and when the finished goods are produced, then manufacturer can export it directly without any duty liability. Whatever duty was deferred gets remitted. So, and at the same time, some part of finished goods can also be cleared in domestic tariff area. That means domestic clearance. That is also allowed. Not only some, even full part, everything can be cleared in domestically as well. But at that time, you will have to pay duty on the finished goods to the extent, on the input contains in the finished goods. Whatever finished goods are being removed in DTA, on that part of input, duties to be paid. That would be both basic customs duty as well as IGST that was deferred at the first instance. But yes, IGST is creditable. That means all laws of GST would apply. GST registration would also be required. I think most of the units which are already there, they are registered in GST. Another important feature here is that there is no export obligation. I would say that is more a duty deferment scheme and not a duty exemption scheme. And it is fully WTO compliant. There's no geographical limitation. There is one single point of interaction with the Customs Department, which is a Commissioner of Customs. If you compare with the other comparable schemes like SEZ, etc., there are 2 points of interaction. One is the Development Commissioner, another is the Customs. But here it is only Customs. So with this initial background and introduction, I don't want to take much time. And I can offer the floor, rather I would give the floor to the organizers. And let me tell you that we also have one presentation ready with Ms. Jamil. She would like to make that presentation in due course. Thank you so much.
Thank you, sir, for your inputs on this. Yes, as we had discussed, I and Mr. were discussing, yes, it is beneficial for deferment of duty payment. So working capital wise, it will be very beneficial to the units. That's a good thing. Now, I think, Nichal, we can ask Jami to go ahead and do the presentation.
Yeah, madam, you can make your presentation. You can share your screen.
Yeah, just a minute. Let me turn it. Sorry.
Yes, madam, you can go ahead with your presentation, madam.
Yeah, let me just make an attempt to share my screen.
Yeah, share screen.
This is the one.
Just touch your screen on the bottom. You will get the green button.
Visible?
No,
not yet.
visible.
Yeah, what about now?
Not yet.
Okay. Not yet, I assume.
Not yet, yeah.
Yeah.
Madam, in the meantime, maybe I can share it from here, and let me see if you can view it.
Have you already passed it on to them? So let them.
Yes.
You can request for screen changes.
Yeah. 1 second. I'll try to see from my computer if I can share this.
Who can start sharing? Also share.
This is, Madam. Can everybody?
Yes, now
This-
something has come, yes.
This is the screen. If Madam, you can see now.
Well, just 1 second.
Yeah, Nishal is sharing.
Yeah, I can stop sharing. No problem.
I can't see.
No, if you want to go through screen by screen, that's fine. If Jamil is fine with it.
Yeah, Madam, if you're fine with it, I'll keep changing the
Scrolling
screen.
it down. Yeah.
I'll scroll it down. You can go ahead.
You can see it. You can enlarge it. It's not being enlarged or what?
Yeah. So, great. Well, I can see. Okay. Okay. Well, thank you. I can see it now.
Okay.
We're on the first slide. So thank you very much for this opportunity. And of course, Commissioner has told all about the history behind it and what went into the minds of the people who were making these regulations. So basically, when we were designing the scheme, we wanted to sort of have a scheme which is flexible, because often we saw that when there is a scheme which sounds excellent, and then people go into it without knowing that going forward, certain demands maybe in the export market, etc., may go down. And often they had to pay huge penal sort of duty because they couldn't fulfill those export obligations. So this scheme is a little different. It does not have any penal provisions for not having been able to sell something in the export market. So can we go to the next slide? Thank you. So as Commissioner has already said, the chapter on warehousing is Chapter 9 of the Customs Act. And of course, this is a duty deferment facility whereby there are certain instances when the importer may not want clearance of the imported goods immediately due to factors such as, say, market price or demand, etc., or even due to paucity of funds, or meeting just-in-time inventory, and he wants to stock it. So understanding that, the Chapter 9 of the Customs Act allows for a duty deferment facility if the goods or if the imported goods are kept in a custom bonded warehouse. So under the Chapter 9 of the Customs Act, there are 3 types of custom bonded warehouse, as we are well aware. One is the public bonded warehouse, where we can store goods of multiple people, say it's a third-party warehouse operator. Then we have private bonded warehouses, where the importer himself stores his own goods. Then we have special bonded warehouses. This special bonded warehouse, as Commissioner has explained, is a special category of warehouses. For our purposes, it would cover, I can say, precious metals, gold, silver, and other precious metals. It does cover supplies to DFS and all, but maybe not very relevant for Section 65. Can we go to the next slide? As regards the framework for the manufacture and other operations in warehouse regulations, MOOWR, we have Section 65 of the Customs Act, which provides the legal framework to do manufacturing and other operations in a customs bonded warehouse. At present, we have 2 regulations. One is for manufacture in a private bonded warehouse. And very recently, we have also issued new regulations for manufacture and other operations in a special bonded warehouse. So it would cover manufacture and operations using, say, gold, silver, and other precious metals. Now, let us first discuss the regulations with regard to private bonded warehouse, manufacturing and other operations in a private bonded warehouse. So here, all types of commodities are allowed to be manufactured or processed So the regulations provide for what type of facilities you require, what type of personnel, what type of security features. It also provides for, say, the eligibility criteria, and the sort of audit that will be done. So this is completely under record-based control. There is no physical control. So the second regulations is for precious cargo or precious metals. So it allows for manufacturing and other operations in a special bonded warehouse using those specific precious metals. Now, the unique feature of this new regulations is that except for the precious cargo, which has to be stored in a strong room, the rest is not under physical control. So the circular is supporting both the regulations. The circular provides for the accounting form, which is to be maintained digitally. Then it also provides for the application format and a list of all the documents that need to be submitted along with it. It also explains the kind of procedures that need to be followed, what is to be expected, and some guidance on the duty payment part as well. Next slide, please. Now, the unique selling point of this MOOWR is that first, there are no geographical restrictions on where such units can be set up. So depending upon business requirements, it can be set up anywhere. Secondly, as I've already said, the circular provides for a single application cum approval form. So there is only one form where the person has to apply and submit the relevant documents. And the customs will also give approval in that form itself, which means that the applicant will know exactly what is the process that the customs authorities will have to do for giving his approval, and what are the exact requirements that he should satisfy. Thirdly, there is only, the application has to be made to the Commissioner of Customs, the jurisdictional Commissioner of Customs, and he is the single point of approval, and there is no committee or any sort of that thing who has to give approval. Next slide, please. So we have also prescribed single account, digital account keeping. This is not just for ease of compliance, but also for regulatory consistency. We don't want multiple accounts on somebody coming and saying this is not sufficient, or this is, why not this? So to ensure that there is uniformity and predictability, we have prescribed a single digital account form through the circular. All these units will be subject to risk-based audits. There's no physical control. And lastly, it encourages full capital utilization because there is no bar on the extent of clearance for either export or for DTA clearance. Next slide, please. Next slide, please. Yes. So what can be done in a Section 65 warehouse? Now, as regards sourcing of capital goods and inputs, we have full flexibility in the matter. The capital goods and inputs can be sourced from DTA also, and you will instantly get input tax credit. Secondly, we can source the capital goods and inputs from the SEZ or FTWZ. And finally, we can source the capital goods and inputs through imports. And there is no bar on the nature of goods that can be allowed in this regard. So all goods are covered, both capital goods and inputs. Next slide, please. Now, as regards the tax liability, let us see what will be the treatment of imported inputs and capital goods. So any and every capital goods and inputs can be imported and used under the scheme. Secondly, the duty on both imported capital goods and inputs stand deferred till they are cleared from the warehouse. That means there is no time limit. Thirdly, if we use the capital goods, say for X number of years, and finally export it, then there will be never any duty on the imported capital goods. And fourthly, if the finished goods made out of the inputs, imported inputs, are exported, then the duty liability will never arise. Next slide, please. Now, when will duty be liable to be paid on the imported inputs and capital goods? So the import duty on the imported capital goods will be liable to be paid if after use we clear it to the DTA. Here there will be no interest liability, but duty will have to be paid. Secondly, if some goods are manufactured using the imported inputs and the goods, the finished goods are finally cleared into the domestic market, then we have to pay import duty on that extent of the inputs that were used and which were imported. In this case also, the IGST part of the duty that is contained in the inputs will be available as credit. So in both these cases, it doesn't matter how long the goods are stored in the warehouse, there is no interest liability. Next slide, please. One more, press. Yeah. So in a nutshell, we can see that for manufacture and other operations in a bonded warehouse, one more, yes. So for manufacture and other operations in a bonded warehouse, what we can do is we can import inputs and capital goods both and avail duty deferment facility. One more press, please. Yes. So we can also buy inputs and capital goods from the DTA or SEZ, as the case may be. And for DTA, we have tax credit facility. Now, after buying the inputs and the capital goods, if some goods are manufactured and if the finished goods are exported, then there is no duty liability. And if some imported inputs were used in manufacturing those goods, then we get zero rating also under GST. If the goods manufactured out of these operations are cleared into the DTA, then we have to pay GST on the finished goods. And import duty on the imported inputs will be payable, of course, with IGST credit facility to that extent. Now, one more unique thing is that because these are bonded goods, the capital goods and the inputs are treated separately. That means when you clear the finished goods, you're not taking into account the duty deferred in the capital goods. So only that amount of duty which is contained in the inputs, that much you have to pay. Finally, when the capital goods are cleared, that time we will take care of the capital goods. So if they are exported after use, then no duty. And if they are cleared into DTA, that time duty will have to be paid on the capital goods. Next slide, please. There are some other unique features of this scheme. It is MSME friendly because there is no minimum investment requirement. As already said, there is no export obligation and there's full flexibility in clearance that resultant goods can be cleared to DTA or exported as per demand. There is no requirement of renewal of permission. So once permission is granted by the Commissioner of Customs, it remains valid till the applicant or the license holder surrenders it or it is cancelled. The inputs can be, recently we have clarified that the inputs can be sent for job work and certain other goods like molds and dies also can be sent for job work. There is record-based controls, and the last is, of course, existing businesses can also apply. Usually I've seen that the applications are for expansions, but yes, there is no bar on the scene. Thank you very much.
Thanks, Jamil, for giving that wonderful presentation.
Hello.
Yes, Mr.
Thank you, Madam, for giving this excellent presentation. And thank you, sir, for giving a complete overview of the regulation. I would now request our next speaker, Mr. Satish Reddy, sir. He is the Commissioner of Customs, ex-Commissioner of Customs, and he is going to make a presentation. And I will be uploading the presentation now.
Nishal, can we ask one question to the madam?
Sure.
While you prepare the. Okay, ma'am, you said the finished goods. Okay, so we understood everything clearly. Suppose if there is a finished goods, okay, sorry, I'm so sorry, capital goods. If there is a capital good which I imported and I use the capital good without payment of duty for 5 years, and in my book it becomes 0 or it become absolute, completely, I can't re-export the goods also. So if I dispose this as a scrap, if I try to, after 5 years or whatever the period, then what will happen? You will still insist duty on that scrap.
The duty will be on the full.
On the.
So, thank you very much. It's an often asked question. So at present, our view is that the manufacturing bond is a duty deferment facility. So there is a duty deferment, but a requirement of payment of the deferred duties would arise when the goods are finally cleared into the DTA. However, industry have asked for depreciation in the matter, as you were rightly saying. So that is still under examination.
Okay.
I would request Mr. Satish Reddy to make his presentation.
Thank you.
No, it's not audible.
Am I audible?
Now you've come a little bit. Just, yeah, go ahead.
So, thank you, Sricity again and Siddhartha Logistics for organizing this meeting. And many thanks to the CBIC officers, Vimalji and Mr. Jamir, for making the presentation and giving this elaborate remarks. I think between the presentations and the remarks we have had now, pretty much all the features of the scheme have been covered. So I'll not really go into the nuts and bolts. Just to summarize that it is essentially a duty deferment facility, but the deferment becomes a waiver if the goods are exported. And the deferment will result in payment if the goods are cleared locally. But even if after 1 year or 5 years, there are no interest liabilities. And you can use part of the inputs for exports, part for domestic exemption or DTA clearances. You can use capital goods for both types of clearances. You can also procure locally following the GST rules. So the essential features of this scheme is that there is significant amount of flexibility. You don't commit to an export obligation, and you can, as you go, as your business requirements or commercial requirements dictate, you can choose what to, how much to import, how much to procure locally, and how much to export and how much to clear locally. And since the payments are deferred, it can, as I said, it can be deferred without limit for years, as long as the goods remain in the bonded premises. There's considerable freeing up of working capital, and there are no interest payments at any stage. As the commissioner said, that though this provision has been in existence since long, it's been completely streamlined in the past 2 years. So much simplification has been done. Digitization too, right from application to maintenance of records to filing a monthly return, everything is digital. And so the simplicity, the digitization, the flexibility, and your savings, I think these together make a very good case for units to look at this scheme. And as they said, it can be greenfield units and it can be brownfield. So those who are already existing can also consider this. Next slide. And I think I will skip this. This is essentially to some of you may be operating under one or more of these, and you have specific obligations, specific requirements. Perhaps these do not have the same flexibility as the bonded manufacturing scheme. It's for each of you to look at your business requirements and your commercials and look at this. But in my view, the Section 65 scheme as it stands now offers much flexibility and can cater to those who have export orders as well as duty orders with all flexibility. And please note that many of these existing schemes have been questioned in WTO. WTO also has not taken a favorable view of some of this, but the bonded manufacturing scheme is fully WTO compliant. It is run by many countries. So I think it's one way that this is, I think, here to stay. The advantages have been, I think, explained again. The duty deferment, which translates into an exemption if you export, the full flexibility that you have. The controls, which prior to 2016 used to be physical, have now been made digital, just based on digital accounts. So there are no physical presence. And conversion of existing facilities is allowed. And there are bond-to-bond clearances also allowed. So I can see going forward a whole ecosystem of Section 65 facilities, each procuring from the other or supplying to the other without any duty payments. I think this is something that is likely to happen in the future. And in one of the most recent circulars issued by CBIC, I think just a week or so, there has been clarity provided by job work. The Section 65 unit can carry out job work for other units and also can send their goods to another unit for job work. And they can even place the imported tools, dies, jigs, fixtures, etc. In a job worker's premises for use there. So that's an additional stream of operational stream of income for Section 65. Now, given the duty deferment and various flexibilities, there are some controls. But as I see that none of them I would think are excessive. They are those which are required by the unit themselves, such as security in the premises, availability of closed circuit TVs and computerized accounting systems. A qualified warehouse keeper who has experience or knowledge of customs procedures, who will be responsible for running the operations, the compliance part of it. And the compliance is mostly through customs audit. CBIC has clarified that it will be risk-based. It could be once a year, once in 2 years, depending on the risk profiling done by the customs system. Records are mostly electronic, and there are a few physical, but that's more for bond-to-bond movement, to confirm that goods have been received, etc. Otherwise, it's mostly electronic. Monthly filing of return is there. So this is about the scheme. I'm sure we should have more time for interaction, so I'll stop here. I think all the remarks and presentations together would have given you a pretty good idea of what the scheme is about. And one thing I should note is that even in the last 2 years, further simplifications or facilities have been given. So I think I would say that CBIC is being very responsive to the needs of the trade, and wherever possible, they have further simplified it. I think that's a very good sign, and I'm sure the Sricity units would look forward to that as well. Thank you. And Nishchal, I'll just hand it over if you want to conclude anything from the industry perspective. Thank you.
Thanks, Satish.
Yeah.
Nishchal, go ahead.
Yeah, I would like to just add it from the industry point of view, which I think that Satish sir and Madam had given a very good understanding of what the regulation is. But in terms of day-to-day business which we have to do as industry, what it holds for us is that we will not be, as industry, which we are getting our inputs, capital goods. Usually it's a practice that if we are a DTA unit, we usually apply for EPCG licenses. So all the new units will not have to apply for any more EPCG licenses. They can remain bonded, and you can straight away import your machinery, and you defer the duty. You're not going to pay any duty at this stage at all. And if you're not going to take the machinery out of your factory, you're not going to pay duty until you take it out from your factory, or if you export again, as it was explained. Also for the raw material and component parts which are required for day-to-day manufacturing, they can be straight imported, defer the duty, bring the stock in the facility, do the manufacturing. If you are selling it in a DTA area, it's only at that point, whatever you used as imported material is the only duty which you are going to pay. Now, this I consider as a path-breaking actually law, which I feel has been given for the first time, because this actually enables any factory to become a bonded and very easily do the exports, because you are now no longer required to go for advance authorization. I mean, everybody knows that how difficult the compliance becomes for the advance authorization, because we have seen, at least the COVID has also shown us that the projects get delayed, the orders get cancelled, and the obligations under advance authorization remain open now. All these things you do not have to be worried about in the new regulation. So it really brings the ease of doing business. It defers your duty, and it brings the next slide. I just wanted to give you a small example, just taking an example of a bottle where a empty bottle is imported and a bottle cap is domestically sourced, either with the payment of GST, or if you have found a supplier in FTWZ or SCZ, you can actually bring it straight as a bonded goods into your manufacturing facility. If you export, you are actually having no import duty to pay. Normally, you would have applied for advance authorization, you would have taken GST credit, you would have, all these things which add up to our transaction cost actually. Now you have the flexibility that if you have an order from local DTA market, then you will end up paying import duty only on the cost of bottle which was imported. And for the full bottle with the cap, you are only going to pay the GST. This was not there earlier. So combined with DTA and combined with export, this becomes the ideal model according to our understanding for every industry. And I feel that slowly the ecosystem is going to be that the customer will ask you that are you bonded or not, and you are going to ask your vendor, are you bonded or not. That's the way the whole ecosystem of our manufacturing and other operation industry is going to be, is what I think. And that is one of the reasons why we and Sricity came together and thought that this presentation needs to be made, because we should be ahead of the industry here. Every industry eventually is going to become a bonded. Here is an opportunity for all the participants who are from Sricity and others also to become bonded as fast as possible. The steps which you need to take for bonding is you need to evaluate, you need to do your cost analysis and factor the cost, whether you are still okay with doing advance authorization only, what is your drawback rate, what are your capital goods which are being which you are using, do you have any outstanding liabilities of EPCG, so on and so forth. Business specific, you need to evaluate your business. Once you have done your evaluation of business and you think that the business model risk is favoring you to go for bonded warehouse, which I'm sure that in most of the cases it is, then you take the next step of making your SOPs, making it a computerized system for keeping a track record of what has come into the warehouse and what has gone out. Appoint a warehouse keeper, do your security process. Now you are fit and ready to approach to the commissioner and make your applications, and you get your license and you are ready to go. That's what I would like to say. And with this, we actually conclude our presentation side of it and throw open the webinar and the conference. If people have any questions, they can ask, feel free to ask, and you can come in. Thank you.
Hi, this is Ashish Khemka from KCL. I have a question for the madam. We have certain EPCG liability. So if we convert our unit to a bonded warehouse, would we be able to, in a way, avoid paying the current EPCG liability in the present time frame, and till the time we are a bonded warehouse, we can say keep on doing operations without paying any duty? Is it possible for units which have EPCG liability?
Thank you very much for the question. It's a very interesting question and frequently asked also. So as regards not just EPCG, but if there is any liability arising from another scheme, because these two schemes are not related, those liabilities will still have to be fulfilled under the requirements of that scheme. Thank you.
Just as a continue to that, does it mean that you can actually go and approach for a foreclosure now, and whatever you might have exported and to the extent of obligation met, you can actually close it, and the subsequent liability do not arise?
Yes, if the agency who is running the particular scheme closes it, then obviously subsequently it can be converted into a Section 65, and obviously only the provisions of Section 65 will prevail after that. So that is one option. If we look at it, Mr. way back, when this advance authorization came something, there was this one-time conversion for EOUs. So while we have not thought about that as of now, that is a line of inquiry that trade can pursue, because
yeah, I get your point, madam. I did my research and homework on this, and I am of the opinion that probably it is possible technically if you consider the provisions of the act which are given, Custom Act, and in my opinion this will end up to be becoming possible. But as you said, madam, that one of the industries who come up with this proposal, we can make a technical submission, and that can be taken to a logical conclusion based on what we are coming up with. But
let me intervene at this point. If I may say so, I am Vimal Srivastava. So I welcome the question, which is very interesting, and I think Jameel has already responded to the extent it is plausible at this moment. But yes, we would welcome any technical submission, as you have just mentioned, and we look forward to examining it in the ministry. Thank you.
I'd like to add another point to it. See, we are a packaging industry. So earlier, before GST, we were getting H forms and for the deemed export that we were doing to EOUs or units doing exports. But now after GST, all that benefit or all those indirect export acknowledgement that we were getting, that has gone. Like there's no acknowledgement that we are partaking in export by supplying packaging material to pack any goods which are moving out of the country. So in this situation, for ever since GST has come in, all our export obligations have come to a standstill. We have not been able to directly export because packaging is a bulky item, like corrugated boxes is a very bulky item to export. We cannot export that. So it was always indirect export. But now we are not able to export, and we have this liability standing on our head, which we don't know how to do because no company is able to give us an acknowledgement that we are partaking in that export. So we are in a fixed kind of a situation.
Thank you very much for the question. Am I to assume that this is after the GST, so a GST specific issue?
This is after the GST, but earlier, since we were getting H form and CT3 for exports,
yes,
now
yes.
There is no such forms available where we are not a direct exporter and we are supplying to companies who are maybe not in, who are not EOUs. So in that case, our export contribution is not counted, which can be offset against our EPCG liability.
Okay, okay.
Maybe Ashish, I suggest that if you could make a small representation and send it, and we can take it this subsequently offline. And this question is good, but I think if you can make a submission on this.
Okay.
So while we have understood the crux of the problem, obviously the solution does not lie here in Section 65, but if you send it to us, we shall send it to the relevant wing, be it the GST or otherwise also.
Okay, thank you, ma'am.
In reality, exports are happening. The packaging material is going out of the country. So logically speaking, some benefit should be available.
Yes, but unfortunately it's not. Like we supply to so many units who are who are doing exports, like our EPCG liability would have been met if we were getting some kind of an acknowledgement in terms of CT3 or H form. But since that is gone, so there is no way we can prove that we are partaking in indirect exports. So how do we get in touch with you, madam? Through Nishchal or through Sricity?
You can make a submission directly also, and you can send it to me also. I'll do my best to come back to you with further details as what you need. Probably once we examine some solution also.
Okay, great. Thank you so much.
Is there anybody else who has a question? Can ask.
Yeah, this is Aranyak. Can I ask a question?
Sure.
Yeah, my question was that is this Section 65 suitable for this repair and return kind of activity, like maintenance operations, and it seems to be suitable for that. But is that one of the key benefits that are available for industries which are into repair and maintenance services?
So you mean to say import repair and maintenance service? You're importing something from
Yes,
outside the country for repair and doing it and re-exporting it.
Yes, it's like global, like
Okay.
like a maintenance hub. Yeah.
Okay. Okay. Jamir?
Yeah, thank you very much. I think it will be more suitable
Yes.
because the crux of the issue that we have seen in sort of importing and re-exporting is that customs always ask for proof of the identity or say that it is the same goods. But once it is in customs bonded warehouse and under customs control, such questions will not arise.
All right.
So it's most ideal. Thank you.
Thank you so much, madam. That's I got the clarity. Yeah.
Next, anyone?
Good afternoon. Seshi. Seshi wants to say.
Yeah, Sashi, come.
How are you?
Good
Good afternoon, all. Yeah, good afternoon, Nishchal. This is Seshi from Vital Paper Products. We are a SEZ unit. I just have a question that, can I use this SEZ unit as a bonded warehouse for my DTZ activity?
Can you?
Nishchal, you understood my question?
Yeah, actually what Shashi means to say is that, does he have the option to actually come out of SEZ and become a DTA also?
No. He is not asking that. Sashi, if I'm trying to get it, you're talking about using your SEZ unit as a bonded manufacturing unit.
For DTZ.
For DTZ.
Yeah.
You're in SEZ.
Is there a provision available or no?
Jamir?
Thank you very much for the question. No. The answer is no.
No.
Obviously, it has to be in a DTA. However, going by Nishal's question, if you so desire, a portion of it can be deregistered and then you can come under Section 65. Thank you.
That's a wonderful solution, madam. And I think that, that there is a provision in the FTP which says that any SEZ who wants to debond from SEZ has the option to become a EPCG. So if the bonded regulation allows the existing EPCG holder to become a bonded warehouse, then I don't see the complication that as why a SEZ cannot. There is a FTP clear provision in the FTP that if some SEZ unit considers to come out of the SEZ scheme, the FTP provides the provision that they can apply for EPCG license and come out of the scheme. Now our bonded warehouse scheme says that if there is any holder of the EPCG license has the option to become bonded. So you can become bonded is what I could feel is this is my feeling. But so madam, you could probably
part of the land can be denotified and you can convert into DTZ. Is that something?
Yes.
Like I have 5 acres, so 2.5 acres can be SEZ and 2.5 acres can be a bonded warehouse for DTZ purposes.
Yes.
That's what madam is saying.
Just to clarify, I think we are all on the same understanding that for us, the important part is that it should be not an SEZ in the sense that it should be denotified. Once it is denotified, there is no problem. there is no bar in becoming a Section 65 unit.
Yeah, but me being a developer, I'll put in a caveat to it that there has to be a provision for non-SEZ movement space, entry, exit. It is not that simple to denotify a portion of any given land, because there has to be access outside the SEZ from DTZ directly and things like that, because we are facing that issue for some of the units. So it is not that simple when you are within a SEZ zone to denotify a small portion of it.
Okay, got it.
So it's operation issues.
Yes.
Okay.
Is there any?
That's it.
Yeah. Is there
Anybody else?
Has any question?
If everybody has finished asking questions, then I think.
Ramesh, I'm Satish here.
Yeah,
I would like to, this is not a question, but more like a suggestion. Commissioner. He has clarified that the audit will be risk-based, but all these units would generally be GST registrants and would also be subject to GST audit. So there's a scenario.
Audio is breaking up, Satish.
Okay. Okay, am I audible now?
Yeah.
Yeah. So I'm just saying that from the custom side, these units are subject to risk-based audit, and being GST registrants, they would also be subject to GST audits. So it's there could be a scenario where there are multiple audit teams visiting these units, maybe in a short one after the other or in a short time frame. So going forward, more so since GST and customs are part of the same department, it's also my suggestion is that you could consider some kind of an integrated audit, which is good both for the unit because he doesn't have to deal with multiple audit parties knocking on his doors, and I think it's also good from the administration point of view because there are no gaps. There would not be a regulatory gap. The same team checking the customs and GST issues may be able to do a better compliance check. So I think this is a kind of suggestion that would be welcomed by the trade and also good for the department if it's feasible. Thank you.
Thank you, sir, for the suggestion. Synchronous audit is the need after hour. We do acknowledge that. So the point is well taken. We'll try to take it forward, sir. Thank you.
Madam, more likely that, we will be the people who will be, we will strive for getting to be nominated as warehouse keepers. And that brings me to the question that if there are multiple inputs in the bill of entry, which is bonded bill of entry, and the output which is manufactured and sold in the DTA market, for paying the input duty on the inputs, you know that, bonded warehouse has a restriction on exchange rate, and ex bond we have, the duty has to be paid on the date on which we do the removal. So because of this, under the current regulation and the current procedures, we may have to file, multiple ex bond bill of entries. Can it be that we will be able to file a single ex bond bill of entry covering multiple bonded bill of entry? This will be a great, flexibility, and this will be in the practical side, it will be required.
Thank you, Nisal, for that excellent point. Yes, you're very right. And this is more of a systems issue than a legal problem that we have. So because initially bonding was designed for just, storage, I think this was not taken care of. But now that we are into manufacturing, yes, we're looking into it, but we'll be happy if all the points that we have discussed and in which clarity is being sought, maybe through an FAQ or in some cases, a circular would be required. It'll be good if you can collate all these points and share it with us through an email or a letter.
I'll surely, madam, do it. Thank you so much.
Okay, I think thanks to all participants, and thank you, Commissioner Mr. Srivastava and Jameen for doing a thorough presentation and making the units understand the benefits. Positive, there will be few units in Sricity who would like to go for bonded manufacturing. As and when, if any units are approaching, we'll positively get back to you and take it forward. Once again, thank you to all, and happy Diwali to everybody.
Just before we end it, please, Madam Jamir and Vimal Kumar sir, please make it convenient one of the days to visit us at Sricity.
Yeah, you're most welcome to come to Sricity. We have always an open invitation to everybody to come to Sricity.
Thanks a lot from CBIC as well, and we have taken note of all the suggestions and discussion that has taken place. We are also looking forward to receiving written comments and suggestions from your side. And lastly, once again, I would thank you for organizing this webinar and inviting us to visit the city. But of course, maybe after the COVID scenario is more favorable, then only we can make any such plan.
Yes, sir.
Thank you.
Thank you.
Thank you. Thank you.
Thank you so much.
Okay.
Thank you so much.
You're welcome. I can go ahead and end the session.
Thank you.